We're off now to Raleigh, North Carolina, and the Wake County Courthouse. Visitors, attorneys, and employees of the court are entering the building and going through the main security checkpoint. Watch closely as this man picks up his personal belongings from the container. Whoops. He has no idea he just dropped his wallet, and now he heads to the elevators. It's not until he attempts to pay a court research fee on another floor that he realizes his wallet is missing. Inside is $1,600 in cash. Fortunately for him, someone returns the wallet to another security checkpoint in the building later that day. Unfortunately for him, it's missing the cash. So security does some sleuthing. Moments after he drops his wallet, this gentleman makes his way through security and apparently becomes aware of the situation. He and the wallet head to the elevators, just missing the wallet's owner. It looks like he's checking out the contents. He goes up to the 4th floor. A short time later, he's back in an elevator. You can see what looks like the wallet here in his folder. He gets off on the 1st floor and turns the wallet into security, minus the cash. He tells them he found the wallet in a bathroom. Security's able to track him down and arrest him in court. What was he doing in court? Defending someone, because he is a defense attorney. He's convicted of misdemeanor larceny, and as a result, he's disbarred, fired from his job, no longer allowed to practice law in the state of North Carolina. Arrangements are made to pay back the $1,600 to its rightful owner. Next, we go to a child custody hearing in Las Vegas, Nevada. The plaintiff is Shelby Bachman, and the defendant, Jonathan King. The couple are arguing over visitation rights for their 2-year-old son, Joseph. The issue is King's unpredictable work schedule. The attorneys are Don Procopius, and for the defense, Machancy Kramer.
Because my client is a UPS driver, his schedule, though, is not a set schedule. It varies. So he has to keep her notified of when his schedule is changing so that she's aware of pickup. She has told him now if he's more than half an hour late, he forfeits his entire weekend and can't see the kid.
Has Joseph gone weekends that he would have expected to see his father without seeing his father?
He has not missed one weekend. Not one.
The threat was made.
Not
I didn't
one.
ask you if the threat was made. I asked if it happened. You led me to believe that it was happening.
No.
My client has worked with him at times that it was till Saturday morning that he picked up.
There is a problem here.
After hearing from both sides, Judge Sandra Pomerantz points to the lack of cooperation between the parents.
What I see here is parties not being creative. But these two need to be adult enough to say, okay, this happened, where do we go from here?
But Your Honor, and I agree with you. And so what she's done is on these times where she's worked with him, but then I think it was within the last 2 weekends.
I thought you said you agreed with me.
I do agree with you.
Okay, so listen to me. You're going to be done with this case when this case is over and these parties are divorced. They'll never be done with this case. Okay? So rather than complaining to me, it's a discussion with Mr. Procopius being creative.
It appears the judge has struck a nerve with the defense.
My client has come up with all kinds of solutions, Your Honor, and it comes down to what mom wants is what mom is going to demand.
Okay, I don't buy that.
Well, Your Honor, that's how it is.
What I'm telling you is, have you discussed this issue with Mr. Procopius?
Yes, I have in the hallway.
Okay. And has it been a matter of making demands or saying, what are we going to do?
No, it's a matter of
been
calling
a
my
matter-
client
Things begin to get personal, and the judge has a few words for Kramer.
I do have experience with you using inappropriate language.
And you know
toward
that I
her.
would admit it if I had done it. And if I was going to do it, I would have done it to her face.
You know what? You want to be a sailor, fine. Go be a sailor in your private life. But don't be a sailor in my court or in my cases.
I didn't.
Again, I don't judge people with sailor language because I use a little sailor language, but only in my private life, not in my courtroom, not to a litigant, not to an attorney. I don't do that because that's not professional. And ma'am, I warn you, one of these days, the State Bar is going to catch up to that. Because if you read the rules, there is an ethical rule about fairness to opposing counsel.
I know that there are also rules about treating people equally without regard to race, ethnicity, or gender. I find it highly objectionable that anyone complains about my language because I know all kinds of male attorneys who have no problem picking up the phone and screaming cuss words at me. So if I am outside there where my First Amendment rights are in full effect, I will say what I choose to say when I choose to say it, and that is my right in this country.
Are you done?
But after a few minutes of civility, the counselor starts up again.
We've spent, 5-10 minutes talking about nothing that is relevant to this case because I, as a female attorney, am being chastised over language that men feel free to use every single day, and they do.
You are giving me a headache because you're yelling, and I don't like having
Well,
a
I'm
headache.
being attacked, Your Honor.
No, you're not. Sit down, counsel. I'm done hearing from you.
Unsatisfied with the parties' solutions, the judge orders an evidentiary hearing, which means the parents will submit evidence against each other and the judge will make a ruling. In a child custody case, it can get ugly.
Your lawyers are going to be painting a picture for me in court. And it's not going to be a great picture of either one of you about the other.
Even after the judge makes her decision, the defense tries one last argument.
Your Honor,
I have nothing more to say, and I want to hear from either one of you. I'm going to set the trial.
I understand that.
So sit down.
The couple's evidentiary hearing is postponed multiple times and has yet to be heard. Most attorneys will tell you it's a pretty smart idea to stay on the judge's good side when arguing a client's case. What's not a good idea is to accuse said judge of serious judicial misconduct.
You know there was jury tampering Wednesday. You saw it yourself.
The man dropping that bombshell is Kentucky Commonwealth attorney Larry Rogers. And on the receiving end is Judge Vernon Minyard. And he's not receiving it well.
Let me tell you something, Mr. Rogers.
You think
I've never tampered with a damn jury in my life, and don't you ever accuse me of that. Do you understand me?
I heard you, Your Honor.
You
Did
better
see-
understand me.
see the
Hey,
letter?
don't talk. You better understand me.
Your Honor, there is an investigation. I will let you know.
Well, you investigate me all you want.
I didn't-
I'm not scared of anything, because I have never done
I
anything
never
wrong.
said you did.
Rogers is actually referring to another case he and the judge are involved in, which includes allegations of jury tampering and corruption in Russell County.
You just said if you become a witness, you have to recuse yourself in this matter.
I don't know what I'd be a witness for. All I did was, there were some jurors that had to be out.
Yell me all you
I'll
want.
yell all I want. This is my court, and I'll do what I want. Do you understand me?
I said that, but I am going.
Go sit down. I don't want to hear anything else from you.
Turns out the allegations had no merit, and Rogers himself would later be accused of prosecutorial misconduct in several cases, though those claims would also be dismissed.
This is my court, and I'll do what I want.
Next, we're in Denver, Colorado, for the deposition of attorney Robert Abrams. Abrams' firm was added as a defendant alongside their client in a lawsuit between two former business partners and are being sued for fraud, conspiracy, and aiding and abetting a criminal by the plaintiff.
Good morning, Mr. Abrams. Do you understand why you've been asked to give your deposition today?
No.
To say tensions are high in the room would be an understatement. Asking the questions off camera is the plaintiff's lawyer, Tom Werge. And on the other side of the table is Abrams' lawyer, Neil Sullenberger.
Are you aware that your firm, Abrams and Associates, is a defendant in a lawsuit that's going to trial next month.
Yes.
Have you had your deposition taken before?
I think so.
When have you had your deposition taken before?
I don't recall.
How many times?
I don't recall.
You're sitting here today under oath, you have no idea whether you've been deposed before?
I've answered that question, object to form, move on.
Object to form is a quick way to object during a deposition and, in effect, ask the attorney to clarify the question.
Have you been deposed
Object to
before?
form.
Object to form, move to certify the question. If you feel that I haven't answered, then you can move for a sanction.
We're going to go ahead and stop the deposition at this point and dial the special master. Good morning. Yes, we are in the middle of a deposition this morning.
But when the special master isn't available, plaintiff's attorney Tom Werge asks the same question again.
Mr. Abrams, have you had your deposition taken before?
And gets the same answer.
Object to form.
Asked and answered, move on.
You need to answer the question.
The question was answered. Excuse me, have her read it back.
Yep.
Mr. Abrams, this is not your deposition.
Please don't harass me.
No, I'm not harassing you.
We're going to move for sanctions
I'm
against
asking you to
If you're not
answer
going
the
to
question.
allow
He just
her-
answered the question.
As the heated back and forth continues, Abrams, who is a witness, begins making his own objections, which a witness is not allowed to do during a deposition.
I'm going to raise, move to strike, find it objectionable, and then move for sanctions for harassment under Rule 30D. You can look it up if you don't know it.
Mr. Abrams, I feel quite confident that if any sanctions are entered in this matter, it's going to be against you.
Object to form.
For continuing to obstruct and not answer any of my questions.
Object to
You
form.
cannot object.
I just did.
You cannot.
I just did. I'm a lawyer. I'm a licensed, unblemished member of the bar. Unblemished. If you laugh at me one more time, we're going to walk out.
We're going to move for 30D3
We're
sections.
going to move for harassment sanctions against you right now.
Things only get worse when the arguments take a personal turn.
We're going to be here for a long time today if you do not answer my questions. I can't even get through my initial questions here because you are being so obstructionist.
That's
today.
because you're a weak lawyer. You have us down here for fraud. Ask us fraud questions.
Okay, let's ask a couple more questions. Mr. Abrams, what are the pills that you just took?
Object to
None
form.
of your business.
Privilege. What are those other pills?
Object to form. Object to privilege.
None of your business. But I can tell you that if you took some of these, they would help get some of your weight off. I can tell you that.
Oh, you're referring to when you called me fat when you walked in here.
Object to form.
If you want to raise your weight problem, Mr. Ward, with the jury and with the special master, please do. But we're not the ones that are sitting here in that condition.
I am going to end this deposition now.
Okay.
Mr. Abrams, we're going to continue it while we seek intervention of the special master.
Fine.
It's clear that you are not here to answer any questions today. We are going to move for sanctions against you and your firm for your conduct during this deposition, and we will take that up with the special master.
And we'll represent your conduct during this deposition.
Please do.
After reviewing the transcripts from the deposition, the special master issued an order for sanctions against Abram. His behavior during the deposition, along with other misconduct in the case, would ultimately earn Abrams a 9-month license suspension.
You have no evidence. Put something in front of me and we'll answer the questions. You have nothing.
Our next story takes us to Clark County District Court in Las Vegas for a kidnapping trial.
Defendant is here. He's in custody.
There's just one problem. The defendant's lawyer is nowhere to be found.
Can you check and see if he's going to join us?
After a 90-minute delay, defense lawyer Joseph Caramango finally arrives in the courtroom.
Judge, I was heading east on Sahara Drive, and I was rear-ended, and my car was undrivable. The person who hit me took off, and
Hit and run.
it was a hit and run, and here I am.
I'm going to tell you, be honest with you, you don't look right this morning. That's why I'm concerned.
Judge, my neck and my back is killing me, but I'm ready to go forward.
You don't think you need medical attention?
I think I do. I think I do, Your Honor. I may have suffered a concussion, Your Honor.
Because you hit your head?
Because of the whiplash, Your Honor. I've had multiple concussions before.
You've had multiple concussions.
Yes, Your Honor.
but I feel like I can go forward.
You know what? Can I just see everybody back in chambers?
Behind closed doors, Caramango meets with the judge and is assessed by a courthouse nurse.
And the record reflects that Mr. Caramango is back in the courtroom. He has been checked out by the nurse. Now, the nurse said you told her you got hit from behind and then you hit a car in front of you. Hey, you left that part out with us.
Yeah, I did, Your Honor.
So you also hit a car? So it was a double hit and run.
I guess.
The judge is becoming increasingly suspicious of Caramango's story, and the prosecuting attorney isn't doing him any favors.
My observations were observing him that there was clearly something wrong with him. I noticed he was slurring his speech. I noticed he seemed unsteady on his feet. And when actually Mr. Caramango came back into the courtroom, he seemed very unsteady on his feet as he walked by and actually ran into our counsel table.
Things only get worse for the defense lawyer when the judge orders him to take a blood alcohol test.
I think you have a concussion. I think you're dazed and confused and can't tell a straight story because you're too intoxicated.
I admit that I did have drinks last night, and I lost my grandmother about 2 weeks ago. I've been under a lot of pressure, Your Honor.
Okay.
I'm aware of that.
So if you came to court intoxicated, you have a problem. Do you understand me?
Your Honor, I can represent as an officer of the court. I am not intoxicated.
Okay. So just go ahead and blow. Let's get it over with.
Go ahead, Caesar.
You want to show me? Okay.
I am stone sober.
Mr. Caramango, if I was you, I would just be quiet at this. Okay, for the record, your blood alcohol is a .075.
Even though his blood alcohol content is slightly below Nevada's .08 legal limit for driving, the judge has had enough.
I have no desire to ruin your reputation or anything. We'll deal with it. I'll give you an opportunity to get it together. But at this point, I cannot absolutely allow an attorney to proceed.
The judge declares a mistrial, and Joseph Caramango's law license is put on disability inactive status. He's prohibited from practicing law in the state of Nevada and has not petitioned the state Supreme Court for reinstatement.